Your Honor, he was at grand jury on Tuesday, and we received an indictment, so I believe they put up pretrial detention based on that.
Oh,
I do have a copy of the indictment if the court needs it.
okay.
The thing is, the case is going to go to the south end. He's got 9 cases. So
Yes.
he already doesn't have a bond in mind with the existing cases. I was going to ask to keep him without bond, then we can deal with him. I think it's suspension. If we just we do something, even though, he's represented by Rudy.
I know, Mr. Russell said that we were to keep him.
Okay. Or,
Oh, no, he said that there's no conflict. We're
I see.
I said, okay.
I can hear a thing you're saying, especially when you stand up.
Okay.
It's like
Yeah, yeah.
talking.
So we don't hot shop now.
I loved it when you went to the podium, 'cause I know there's stuff on here you can't take away from the story. Do what you can.
Okay.
I was surprised by
I
that.
don't hot shop now.
Okay.
I'll have to just put down one.
Why did he need that? How loud I am?
We want you to sound as good as you look, okay? So we're gonna do this, we'll get this a little closer to you.
Okay.
We should have microphones.
You gotta sit at the
like,
kids'
on
table,
our
that's why,
phones.
you know, just sit down here at the kids' table.
Right.
Now that
You can
we
walk.
do that, that's, that'd be good. Move around.
What, sit at the kids' table?
Well, we just have a bad habit of pacing. But I thought,
Plus, it's better also if you're trying to present your you can walk, it's not in front of the podium all the time.
yeah, but if I'm doing circles around the podium, that's not a good look.
Or if you're with Judge Stone, don't come out from behind the podium.
Just walk a little bit.
Okay, so you approve of my. I have to shut my doors in my office. Where else? McDonald's still downstairs, it's on the way up.
This is State of Florida versus Andrew Joshua De La Rosa, 24 CF 1700. A pretrial detention hearing. Go ahead.
Your Honor, I guess I'll go ahead and start. Your Honor, Mr. De La Rosa was previously before the court on this case as well, on a sexual battery of a child under 12, and also 11 counts of possession of child pornography and 10 counts of promotion or production of child pornography, along with unlawful use of a two-way device. At that time, the court found that it was appropriate to hold Mr. De La Rosa with no bond, pending resolution of the case based on the nature of the charges and the danger to the community that he posed. Since that time, Your Honor, there has been an additional development. We received an indictment from the grand jury on another count of sexual battery of a child under 12. It is also a capital felony, possibly even punishable by death. We are asking the court that there's been a substantial change in circumstances to even have a greater flight risk, so we're asking the court to continue the no bond status. I do have a copy of the indictment if the court or the defense needs it.
And what does the defense say?
Your Honor, my client would ask that the court set bonds on these counts. Something that is within his reach. He is agreeable to an ankle monitor at $1 a day. He would just like the opportunity to be able to fight these charges from the outside, and he's asking the court to consider a low amount cash or professional bond for each of these counts. Your Honor, he's also indicated that he wishes for the court to know that he is not a flight risk, that he wishes to fight these charges, and it is his intent to remain here and answer to these charges. He would just like the opportunity to be able to do it on the outside.
I don't know if I need to appoint the public defender again, but I will, based on this indictment. And based on what he's looking at, capital felony and the arrest report, possible death sentence, and numerous charges against children, I'm going to find that he's a flight risk and no bond on each count.
Thank you, Your Honor.
This is the thing. Sorry. Oh, okay. If the court's willing, we can do that now.
We can do it now.
Yes, Your Honor, if you don't mind.
All right, what's he charged with? What, capital sexual battery on a
Plea
child under 12?
2 counts of that, Your Honor. Yes, sir.
All right, Mr. De La Rosa, you're charged with 2 counts of capital sexual battery on a child under 12. You have the right to remain silent. You have the right to know the charges against you. You have the right to an attorney. If you can't afford an attorney, one will be appointed. I've already previously appointed you public defender on this case, I believe, but I'll reappoint the public defender. And what is the public defender's plea on that?
Your Honor, we're entering a not guilty plea. We request trial by jury.
All right, we'll set this for, do we need to set it, will we just set it for, we just set it for December 30th or something?
I mean, we can leave on the pre-trial, Your Honor, the regular cycle that he was on.
All right, we'll just leave it on October 28th.
And Your Honor, just for clarity, it was the 2 counts of the capital sexual battery, then there are also 10 counts of possession of child pornography, 10 counts of promotion of child pornography, promotion of production, and also 1 count of unlawful use.
All right. Well, I put no bond per count on all counts in my order, and it said I put numerous charges against children based on an arrest report and grand jury indictment. No bond per count.
Let him know. I'll see him later this afternoon.
I believe was he already arraigned on those other charges?
No, Your Honor, that was the arraignment for the other charges was today, and then the second capital sex came since then. We just put it on the same case number, though, so that everything would travel together. They're the same
All right.
operative set of facts.
Tell me exactly all the charges he's here for arraignment on.
Your Honor, he is here for 2 separate counts of capital sexual battery on a minor, and then 10 counts of possession of child pornography, 10 counts of promotion or production of child pornography, and then 1 count of unlawful use of a two-way device in the commission of a felony.
Is that under 2024 CF 1700?
Yes, sir, we put them all together in one case.
Okay. So, Mr. De La Rosa, you also have those charges against you. You have the same rights that I've already previously announced on the 2 capital felonies. And the court will appoint public defender on all those charges also. And I presume you're entering a not guilty plea, Ms. Rivers?
That's correct, Your Honor, not guilty, and request trial by jury on all counts.
All right, October 28th, be next court date. Thank you. All right, this is 24 CF 2048, State of Florida versus Rashawn Schaffner.
How you doing today?
Mr. Schaffner, this is a pretrial detention hearing. You're charged, I believe, with battery on a firefighter and in 24 CF 2048 and 24 CF 2049, conspiracy to smuggle contraband into a detention facility and possession of a weapon or ammo by a convicted felon. Is that correct, Ms.
Yes, Your Honor, that's
Leon?
correct.
Okay. His current bond, I imagine, is no bond. Is that right?
He doesn't have any bonds on the new cases. However, for the court's knowledge, he has 9 other felony cases open in the South End in front of Judge Ketchel. And the reason why those 2 cases are here is because he committed those crimes while in jail, incarcerated in the Okaloosa County Jail. He already, in some of the prior 9 cases, does not have a bond. The bond was revoked pursuant to a court order to revoke the bond. I was going to ask the court, obviously he's a danger. He keeps committing crimes, violent crimes, even in the jail. The allegations about the battery on law enforcement is described as a very vicious attack on the correctional facility guard, and he received injuries. I believe that he should be held without bond. Again, he does not have bond on other cases, and if his attorney wants to reapply for a bond in front of the presiding judge, which is Judge Ketchel in Division 1, then he could do so.
So he has no bonds by Judge Ketchel?
Correct, in some of the cases that he has prior to this.
Did he have a pretrial detention hearing in front of Judge Ketchel on those?
No, because they're older than the pretrial detention statute that came out.
And then he's got these 2 charges in front of me?
That's
Yes.
correct.
Are they going to be combined? With
Yes, they will be transferred to Judge Ketchel.
Has he been arraigned on these new charges, or is that for this afternoon?
No,
Yes.
it's not even this afternoon, I don't
He
think.
hasn't been arraigned on these charges yet, Your Honor, and just because he's got a no bond on some cases isn't a reason to give him a no bond today. And he is presumed innocent until he is proven guilty, and we would like the court to take that into consideration. He's charged with a 2nd-degree felony, a 3rd-degree felony, or 2 3rd-degree felonies. He's entitled to a bond, and we are asking the court to give a cash or professional bond.
These are false charges too, Your Honor.
Well, it doesn't do any good for me to set a bond. You have no bond on a bunch of other cases, so perhaps Judge Ketchel, when it gets combined, will consider it all and set a bond. But I think with all this, there's a potential flight risk, so I'm going to set no bond on these 2 charges. But, maybe the public defender can work it out and Judge Ketchel could set a bond, but he's already set no bond. I can't undo what Judge Ketchel's done, so it would be it'd be hopeless or pointless for you to post a bond.
There's
It'd
only
just be
no
a waste.
bond on my reinstatement charges. I was once out on bond before. Them charges are the only charges that I do not have a bond on.
Okay, well, it would be pointless to post a bond and then you still have no bond, so, thank you.
Good afternoon, right here. Good afternoon, Judge. Jennifer Flowers with the Office of Regional Conflict. This is State of Florida versus Thomas Stacy McDonald, 24 CF 1992.
Your Honor, the state wants the court to know that he is a big danger to the community, given several factors. One, the facts of the case. I know we are today on 24 CF 1992. However, he was arrested right prior to this on 24 CF 1961 for aggravated battery because he waited for the victim in his car, who was driving in the car, and he hit the victim's car with a baseball bat. In the case that we've here today for the burglary with battery, the victims are cooperative. There are independent witnesses. The allegations is that the defendant showed up from behind the bushes in front of the victim's residence, saw the victims, and he approached the victim with a baseball bat, intending to cause harm to the victim. The victim was able to retreat in the house. However, the defendant proceeded to smash the baseball bat against the doors and the windows. The problem is that the concern that the state has is that prior to committing this burglary and attempting to batter the victim, he had sent threatening text messages the day before to the victim's sister saying that he was going to go and kill her brother. And in fact, the following day, he committed this. After this happened on 8/8, on 8/13, on 8/17, law enforcement had to respond again to the same area for an armed disturbance. And that's the battery I was referencing earlier. The problem is that the defendant knew that he had a trespass warning from that area, and he knew it, and he told the law enforcement, yet he was there to cause bodily harm to other people. Yes. Of great concern also is the prior record of this defendant, Your Honor. Just by the prior record, he scores 96 points. He just got out of prison in 2022. The state will be seeking PRR status, which will make him eligible for life in prison. He's already charged with a first-degree felony punishable by life for the aggravated assault with the burglary. The offer from the state on those two cases is 150 months. He scores a minimum of 141 months, and maximum is life. I think I know he's a danger to the community. He makes threats, and he follows through with the threats. He even threatened law enforcement. He's got 2 counts for death, and he resisted. He should be held without bond if the judge is inclined to give him a bond, notwithstanding all those facts and the prior record. I also want to mention that he has a prior failure to appear, misdemeanor, in his criminal record. He's a flight risk. He's a danger to the community. If the court is inclined, the bond should be commensurate with the seriousness of the charges. He's got 1 second-degree felony in 1 case, as 3 misdemeanor, and then a second-degree felony, written or electronic threats to kill, and then a punishable by life felony. He's definitely a flight risk. If the bond were to be commensurate, at the very least, I would ask for a $100,000 on the burglary of dwelling, $50,000 on the second-degree felony, the written threats to kill, Criminal mischief, $10,000. And then for the aggravated battery, second degree felony, I would ask for $50,000. The 3 misdemeanors, $5,000 each, and GPS at $1 a day. Obviously, no contact with the victims, witnesses.
What did he go to prison for?
He went to prison for, Judge, it's a long list, but I can, armed burglaries of dwelling, several burglaries of structure, possession of cocaine, grand theft.
Based on the failure to appear, pending charge, possible life sentence.
Your Honor, may the defense be heard?
Yeah.
Your Honor, because my client has said some things to me that I just want to make the court aware of. He is telling me that the alleged victim in this case, that this did not occur, that this was a response to a beating that occurred to him back in June of this year. He was in the ICU of Fort Walton Beach Trauma Center and received 15 staples in his head due to the beating of the alleged victim in this case. I have not confirmed that. That is something that I would confirm later. He also wants the court to know that he was living at the address of this incident. He had been asked to leave for a couple of days by his girlfriend, one of the witnesses in the case, and that he was living at this address. And I just want to point out that and I think the state stated it, that there is a prior failure to appear, but it's a misdemeanor.
Only thing I wanted was my property from the house. That's all I wanted.
Well, I'm going to set no bond at this time, but then you can get that verification on the medical and all that kind of stuff.
Yes.
And you can certainly file a motion for bond at another hearing.
Thank you, Your Honor.
Okay, thank you.
I'll come see you. Let's file another motion.
All right, next.
Judge, I do have some score sheets from this morning.
Okay.
Your Honor, may I be excused? Thank you.
I spoke with the defense attorneys on the score sheets and they were correct.
Are we going to have any VOP hearings this afternoon?
I do have one, but I'm not sure what Mr. Gibbs is gonna do with the case, so.
I have one, Judge.
Pardon?
Patrick Medina is the one that we have.
please.
Is what the,
At 1:30.
saying was that, no, it was